The exchange of information by disputing parties in accordance with a process that they bought into, that was designed by the guided choice neutral, is one of the most essential parts of guided choice dispute resolution for one key reason. It's been my experience that when parties say they're not ready to begin to negotiate settlement positions, what they're really saying is that they're lacking enough information for the business people, for the principals, the decision makers, to assess whether or not it's in their strategic best interests to settle at this point or to proceed into binding dispute resolution, perhaps arbitration or litigation. And that's really important because when you force business people into a negotiation setting, the sort of prematurely convened mediation that is so typical of design and construction mediations that fail, and you say, hey, let's get together and let's start to negotiate before the decision makers have enough information to assess their strategic best interests, what you wind up doing is force the parties into taking opposite positions. And you have this positional negotiation where everybody tends to become upset with the other parties in the process. And I think this is one of the reasons why mediation tends to fail. Now, even though I'm a big advocate of mediation, and particularly mediation that is conducted in accordance with the best practices and principles, which is shorthand for guided choice dispute resolution, I would never suggest that any of my clients surrender their strategic best interests or engage in any sort of baby splitting. What I'm always interested in doing as an advocate is making sure that my clients have the information that they need in order to make a decision about whether it's best for me to proceed into arbitration or litigation, or whether we should continue to try to negotiate a mediated settlement. And so, a guided choice neutral should be focused on what information do the disputing parties require in order to better understand a variety of things, including, what's happened to date? Why have the parties been unable to resolve this dispute themselves? What's behind the positions that have been taken so far? And what can that tell us about the positions that the parties are likely to take in the future, and when they may run into impasse when they're conducting settlement negotiations? I think the guided choice neutral needs to be focused on helping parties understand, what are their future interests? Okay. What's likely to happen in this mediation? What's likely to happen if you proceed into litigation or into arbitration? And so I think that to empower the business decision makers to understand the answers to these questions and where their strategic best interests lie, I think that the guided choice neutral needs to identify the information that must be exchanged by the parties or obtained in some way, whether through Freedom of Information Act requests or maybe some sort of requests to third parties. What is the information that's going to influence the parties' settlement positions? And one of the things that guided choice neutral absolutely needs to take into account is whether or not the parties have equal access to the critical outcome relevant information without engaging in arbitration or litigation discovery, possibly without having the benefit of subpoenas that could be issued to third parties. I certainly have been involved in mediations that cratered because one party had the critical information that everybody needed in order to have a fair damages calculation be run. That party wasn't willing to share it. This completely deprived the other party of the ability to understand where their interests lied. And they wound up being forced into a time-consuming, destructive, and expensive binding dispute resolution process, litigation, where the party who wanted the information that was possessed by the other eventually got it, but they obtained it late and after a lot of avoidable costs and expense. So, a guided choice neutral needs to be focused on, do people have equal access to this critical outcome relevant information? And there are just so many different ways that a mediator could facilitate, information collection and exchange. I suppose that like on one end of the spectrum, like the easy side would be a collaborative information exchange, of information that could be, light, or it could be more comprehensive just between the parties themselves, right? If they have the information that they and the others need, just amongst the 2 or 3 or 4 disputing parties. They can agree to some, limited information exchange for the purposes of this settlement attempt only, which doesn't preclude reverting to a broader scope of discovery using traditional litigation or arbitration discovery requests or subpoenas. If it becomes necessary for the parties later to get to some sort of formal and binding dispute resolution process rather than, the sort of voluntary settlement attempt that is synonymous with mediation. Now, I suppose on the other end of the spectrum would be, something that's much more advanced, and it would have to go beyond the parties just exchanging information between themselves. And so this is one of the reasons why a guided choice neutral has to have enough litigation and arbitration experience and experience with discovery and discovery disputes in particular to understand how to help the parties reach an agreement on, when and how they might, dip their toes in the water of arbitration or litigation to be able to, use arbitrators or judges, which are going to have greater power to compel a reluctant party or third party to share information, perhaps through the use of subpoenas, as a tool in the toolkit to facilitate the mediation. There's nothing inconsistent about guided choice dispute resolution and the initiation of binding dispute resolution procedures like arbitration or litigation if there's something to be gained from the binding dispute resolution, right? You can go into litigation for the purposes of getting subpoena power to subpoena a third party to get the documents that are relevant for the disputing parties to have a meaningful mediation, right? You don't have to necessarily plunge all the way, neck deep into litigation or arbitration. You can, just wade in a little bit in order to take advantage of some of those procedural tools that are available in litigation or arbitration, but perhaps not in mediation. That's true not just for, discovery and the exchange of information and the collecting of documents. It can also be useful to resolve procedural or substantive issues that may, be a roadblock in the mediation. One that comes to mind in particular is, what would be the scope of electronic discovery, the exchange of electronically stored information, say, for example, in federal court litigation, because with all of the relevant evidence now being in emails and text messages, and with so many different custodians of the information and so many repositories of electronically stored information, the costs associated with electronic discovery can be one of the key things that might motivate a party to settle. And so, dipping your toes into the water of a little bit of federal court litigation, at least in the early stages, and working with the judge to try to understand what will be the scope of an exchange of electronically stored information, which, generally is not total because that would be cost prohibitive. When the parties understand what the judge is going to order the disputing parties who may not agree on this issue to do in litigation, they can at least have an understanding of what the costs are likely to be if they're not able to resolve the case through mediation, which can be an essential variable that a party would take into consideration when they were assessing, for timing reasons and budget reasons and other reasons, is it strategic for them to negotiate a resolution through mediation, or do they really have an option to proceed, cost effectively on, terms that they can live with into litigation? Like going a little bit into the arbitration or litigation process is not inconsistent with continuing the guided choice mediation process. And in some ways, it can be part of an information exchange in accordance with an agreed process that is conceived of by the arbitrator, but bought into by the parties. And it's important to also remember that there's nothing inherently valuable about information exchange, right? If I just dump a lot of information on you or be I'm the recipient of a data dump, that's not necessarily valuable. What's valuable is if the right information, targeted information, okay, that a party needs in order to assess their strategic best interests, which would flow from the earlier stages of guided choice, right? The guided choice neutral's diagnosis of the reasons for impasse, the process going forward, what could derail settlement negotiations, the neutral will have an understanding after these confidential discussions with the parties about their needs and the specific information that they need to be exchanged based upon those confidential discussions. You wouldn't want to have, like a ship's passing in the night phenomena where, okay, we're going to have a mediation and an information exchange. And here you go, here's a lot of useful information that you can't use, or something similar. It needs to be the right kind of information, and in order to have a meaningful process that is different than the typical mediation, where the mediator sets mediation date too early and the parties are convened together too early, and all that's happened has been an exchange of legal briefs that discuss issues which are typically not what are hanging the parties up, and really not what is driving them apart in their settlement negotiations. So, it's not just an information exchange, it's an information exchange that is targeted and meaningful and conceived of by the guided choice neutral based on his or her confidential discussions with the parties, and then, with the buy-in of the parties, right? Because mediation is an inherently voluntary process. So, a neutral that wants to just shove the parties around or say you have to do this, because I say so, is, obviously setting the table for a mediation that's going to fail. So, to make this a little bit less abstract, what would be an example of a situation where the parties would be able to meaningfully advance their dialogue around settlement and allow the parties to assess whether or not it is in their strategic best interest to settle now, or to fight on in litigation? What would be an example? One would be the way that expert witnesses need information and play off each other, and could work together on something like evaluating like valuation. Okay, so what I'm talking about here is quantum. We're talking about calculation of damages, right? Not the question of liability, because obviously if you run a red light and you don't get into an accident, you're negligent, but there's no damages. So a lot of times people spend too much time and emotion thinking about the liability, the negligence issues. Now I want to talk about the measurement of damages and the role of experts and the role of the information exchange, and how you would go about maybe closing a gap on the parties' understanding about what would potentially be recoverable damages if they were to revert to litigation or arbitration. And so the parties working with the guided choice neutral may be able to determine early on in the diagnostic phase that maybe the two parties have been using different methods of determining settlement values, right? Which may have caused them to be really far apart in terms of dollars. And maybe this is the thing that is driving the impasse, right? So one party might say, there's some discrete issues here and you're owed a couple dollars here and there. The other party might say, well, this is my overrun of what I projected to spend on the whole project, and so you owe me that, right? And so the different methodologies that the parties are using may be the reason why they have wildly dissimilar understandings of what kind of dollars would be recoverable in litigation. And so a guided choice neutral might be able to say, okay, I've spotted an issue. The people are using different methods of determining settlement values. We're going to have to figure out which is more appropriate. And it may be the case that there needs to be an exchange of information from one party to the other, so that the experts are able to say, well, look, this is one of those cases where, there were really only a handful of issues that one party is responsible for, and it drove the entire overrun. So a more holistic comparison of what was the projected cost to execute the project versus the overrun may be more appropriate. Or it may be the case, once the information is exchanged between the parties, that the neutral is able to help the parties and their experts understand that this isn't the liable party gets hit with the kitchen sink for quantum situation. It may be the case that we really can measure the damages that flowed from the discrete issues discretely. And so maybe this method of valuing, quantum is more appropriate. And so, the guided choice neutral can explore, developing a consensus methodology with the experts and the parties, and this can be done as part of the confidential discussions between the parties and their experts and the guided choice neutral. And, this can be done in private before the parties are ready to do it in public, in open view of the disputing parties and their experts, and work through prediction theories or key variables that might be key components in the basis for an evaluation, right? And information can be exchanged in support of this, right? Because, this video is my attempt to explain why information exchange in accordance with a process that's agreed by the parties, right? Because you need their buy-in, as conceived by the neutral, is such an important part of guided choice dispute resolution, right? And so the expert can meet with the parties, and their experts, and they can explain their protocols and their opinions, and they can do it. And this is so important, without preparing extensive written reports, right? And there's a couple reasons why this is important. Number one, if you're really an expert witness who is in the business of providing expert testimony, once you commit something to writing, you've kind of like lashed yourself to the mast of the boat, and you are going to sail into the storm no matter how rough the seas get, because once you've committed yourself to a position in writing, you look bad if you change your position. So, working through these things before the parties prepare their written reports can be really constructive, because it avoids the difficult or problematic later change in opinions that might not be something that, an expert could tolerate for face-saving reasons. And of course, the drafting of expert reports is something that's expensive, right? So there's a good reason why we wouldn't want people to spend a lot of money on something that might not be constructive, so they wind up stuck in a position that they're not happy for moving away from, right? So, one party's expert may need data from the other party to form opinions that would be useful at this stage of the discussion, but lacking the data that they need, the expert might, clam up, they might not be able to provide the business people what they need to decide whether or not it's in their strategic best interest to settle or not, and this might be the reason the mediation craters, is just unequal access to information, which is driving behaviors of opinions of experts, which is driving behaviors of opinions and opinions of the lawyers, who might say, well, too bad, mediation failed. We need to have no stone left unturned, scorched earth discovery so that we can get the answers to our questions, when in fact, this is the sort of thing that can be worked through by a thoughtful, neutral, a mediator that is using best practices, that is using the guided choice dispute resolution practices. And I think that these expert sessions really need to precede settlement negotiations, right? These early informational sessions with the experts can make it possible for the experts, either jointly or individually, to report to the guided choice neutral on a range of possible outcomes. And maybe there can be some consensus developed between the parties about what would be an aggressive, bad outcome for one party, or, a very conservative bad outcome for a party. And, rather than have each party get dug in on whatever report their expert wrote, maybe with half the information they need, and then, proceed into this meaningless battle of the experts at a mediation that will result in the mediation ending in people being upset. So if the parties and their experts are like ships passing in the night on many issues, one would be how experts calculate damages, and do they have the information they need in order to avoid a procedural problem that is inherently avoidable. This is just one of innumerable potential examples of how information exchange in accordance with an agreed process that's bought into by the parties and conceived of by the guided choice neutral with the help of the parties is something that might allow the parties to circumvent something that might otherwise doom a mediation that could have been constructive. So information exchange in accordance with an agreed process is one of the fundamental tenets of guided choice dispute resolution.